Special Investigative Committee meeting to order. Everybody will notice in your folder we have an agenda. Wanted to just get us organized here, and we need to adopt our committee rules. We do have minutes from our last meeting back. Was that all the way in September? Good gracious, seemed like it was later than that. And then we have Mr. Josh Belafonte, our outside counsel, to give us an update on the status of the litigation that's been proceeding in this matter. So I'll give everybody a chance to review the committee rules that are in your folder. These are identical to the ones that we had the last session. This is, of course, a reconstituted committee from the previous Senate Committee on Investigations. Y'all take a second and look it over. I do want to welcome Senator Kim Jackson to the committee, the new minority whip. We lost Gloria Butler to retirement, and Senator Harold Jones, who was a member of the committee, was elected minority leader, and he will remain on the committee. He had been the whip, and his replacement, Senator Jackson, will be a very capable replacement here on this committee. All other members remained the same. All right, does anybody have any questions about the committee rules? I believe these were unanimously adopted last time with bipartisan support. All right, we got a motion to approve by the majority leader. Second by the vice chairman. Any discussion on the rules? All right, then all in favor, raise your hand. And any opposed? Likewise, once again, they pass unanimously. Also in your folder, you will find the minutes of our last meeting that was on Friday, September the 13th. You'll remember at that meeting, we also went into an executive session to get an update on the pending litigation that we had in an attempt to enforce a subpoena in this case that I suppose would not be reflected, but that happened at that meeting. Any comments, changes, corrections, additions to these proposed minutes for Friday, September 13th, 2024 meeting?
Motion to approve.
All right, we got a motion from the majority leader to approve these minutes. Is there a second? Second from the vice chairman. Any discussion? All right, all in favor of approving the minutes, raise your hand. And any opposed? All right, with those two pieces of business out of the way, we're now organized, ready to go. You also have in your folder Senate Resolution 5, and that was passed very early in the session that reconstituted this committee. And you'll note that in this resolution it gives us the same charge, and it also allows us to use the same, any of the evidence that we had accumulated or testimony accumulated in the past will be cumulative, so we don't have to recreate the wheel here. We'll start from where we left off. We had pending litigation in an attempt to enforce a subpoena that we had issued, both a witness subpoena to Madam DA Fani Willis, and we also had a subpoena for production of a number of documents, and those were objected to. So I'm going to ask Josh Belafonte, our outside counsel, to review for us, and you can kind of start at the beginning, Mr. Belafonte, what your role has been. You gave us legal advice, and then walk us through the various litigation, because we were sort of preemptively challenged at one time, then we issued the subpoena, and there's been litigation on that. We just need a thorough update where we are so we'll know what we can do here going forward.
Sure. Thank you, Mr. Chairman, members of the committee. Y'all may remember that Friday the 13th, I had to leave here, and then we had a Zoom hearing before the court. That hearing was on the district attorney's motion for preliminary injunction to effectively enjoin the Senate from enforcing the subpoenas, whether both the witness subpoena, and by that it would be that she would come to the committee and testify, and also the subpoena for documents. We argued at that hearing that whatever the court may think about the Senate's authority, the district attorney's authority, no one had moved to enforce anything yet because the subpoenas had just been, deemed untimely. The documents were due the week before the 13th hearing. She did not appear to the 13th hearing, so there was no enforcement at all. The court agreed, said that it did not meet the standard of an injunction. There was nothing to enjoin. And then about a week or so later, the court entered a scheduling order where she was going to have a hearing in December. I believe it was the 16th. No, that was a different hearing. Sorry, it was earlier than that, in December, and she was going to have briefing on it. In the interim, the decision was made to have a individual motion filed with the parties being the Senate committee itself. Also, in their individual and official capacities, Chairman Cowsert and President Pro Tem Kennedy, reasons being in the role of chairman as representing the committee, and as the role of President Pro Tem representing the Senate as a whole, because there was a question of whether the Senate itself could issue subpoenas unicamerally, or if subpoenas were valid only if issued by the Senate and approved by the House, or issued by the House and approved by the Senate. So that's why those parties were chosen. On December 23rd of last year, the court issued an order granting effectively all of our arguments on the merits, and I'll walk through them so you can understand what was argued and what the court's reasoning was. The first argument that was made by the district attorney was that the Senate, as I was indicating, cannot issue valid subpoenas unilaterally. What the court held, and this is based on fairly long-standing Georgia precedent, is that unlike Congress that has specific enumerated powers, they have to trace something to the Foreign Powers Clause or the Commerce Clause, the Georgia General Assembly has implied powers. In other words, if you're not stopped from doing something by the state or federal constitution, you can do it. And on top of that, you cannot pass, and by you I mean the legislature here combined, cannot pass statutes to minimize or reduce the Georgia General Assembly's constitutional authority. And that will come into play in a moment. So that was the first thing that the court said, is that that implied authority is quite broad. She then recognized, as we had argued, that each chamber can adopt their own rules and create committees. That's in the state constitution, Article 3, Section 4, Paragraph 14, and that mattered because the Senate chamber's own resolutions could, in effect, trump a statute. Why? Because a statute can't limit the authority of the General Assembly, and that comes from a case called Coggin versus Davey in 1975. Mr. Morelli, with legislative counsel, who had presented on the 13th, walked through a lot of this analysis and authority. That case involved the Open Records Act and whether a committee of the Senate was subject to the Open Records Act. Even though the text said it was held that ultimately it was not. Then the court held that the petitioner, with that kind of framework, which is the one we argued, we said really the burden is on the district attorney to show why the Senate cannot do something, as opposed to the burden being on the Senate to show why it can do something. The court agreed and said that the petitioner failed to show that the Senate was prohibited in issuing the subpoenas. She cited two statutes that are in the code, one dealing with the Legislative Ethics Committee that does have joint subpoena requirements that would be for the House and Senate, and one for investigation, which says that the General Assembly has all of the authority of the Attorney General when investigating. And so their argument was General Assembly means both chambers. The court disagreed and said, at best, that would be a statutory limitation on authority, or as we said, the General Assembly is made up of the House and the Senate, and therefore each has some power independent of that in terms of legislative authority. And so the subpoenas were then deemed effective, and that the state Senate has the power to issue them through the committee, because the Senate Resolution 465 delegated the Senate's power properly to the committee. The committee acted pursuant to that. The next question was, well, could the committee issue subpoenas after sine die of last year? And the argument was that the committee was ineffective. It could not pass binding or any kind of enforceable provisions because the legislature had adjourned sine die. The analysis here was largely similar. There's nothing in the state constitution that prohibits the state Senate from either issuing subpoenas and enforcing them after sine die. The state constitution authorizes each chamber of the General Assembly to create committees, and it can create the rules of those committees. And the rules of this committee and Senate Resolution 465 said that the committee can work at a time and place deemed convenient. So that was deemed sufficient to get you past sine die. Now, after sine die, the committee could not pass binding legislation. Nobody argued about that, and that was the example of kind of where the limit was going to be placed. So the next argument that was made was that the subpoenas violate the separation of powers provision, that the legislature was encroaching upon. When it started, we weren't sure what branch the district attorneys were in. We now know, based on the Gonzalez case from the Supreme Court, that the Office of District Attorney is in the executive branch. That was a case involving the Open Records Act, but the court cited Dean versus Bolton, where it was held that the Attorney General could in fact investigate members of the legislature, that was not a violation of separation of powers. We also argued, although it's not in this case, it is has been held by a different court in Fulton County, Superior Court, that there's a specific provision in the state constitution authorizing the General Assembly to provide by legislation means of disciplining and in fact setting standards for the removal of district attorneys. That is being litigated in another case that we're involved in for the Prosecuting Attorneys Qualifications Council, but I think that also supports that it can't be a violation of separation of powers, because what the committee is doing is investigating, and its inherent authority to investigate, to follow through on that constitutional authority to pass legislation regulating the district attorney's offices. So then the court said, well, it's clear that the Senate can issue the subpoena. It's clear the subpoena is effective, but she was not going to require enforcement of the subpoena at the time. The court was not, and wanted to give the district attorney an opportunity to object to the scope of the subpoena, and it really focused on the subpoena for documents. The district attorney was ordered to provide a privilege log explaining if documents were being withheld, why, who is the parties to. So if you're looking at an email, for example, who's it from, who's it to, generally what's it about, and what is the basis of the privilege, and to further provide more specific objections other than what I've kind of walked through now, which is that the subpoena itself was invalid. The district attorney responded to that, but did not provide specific objections, did not provide a privilege log, and so our response to that pointed that out and asked the court to demand that the district attorney either comply with the court's order, or at this point, really, it's kind of two strikes, you're out. Go ahead and produce the documents, at least the documents that have already been produced in other cases, in requesting information on the same thing. We're waiting on that to be ruled upon. The order from December 23rd did not talk about any distinctions or limitations on the witness subpoena, so we know that's enforceable, but it pretty much held everything back and said, let's work on the documents first, is how I think the implication is. Let's work on the document piece first, then we can talk about the witness subpoena. On January 17 of this year, the district attorney moved to dismiss the subpoenas on the grounds that the former committee is no longer in place, and therefore the subpoenas are void, moot. It's a combination of kind of the two. We responded to that and said several things, pointing to the Senate resolution that says that the Senate committee is reconstituted, that the fact that the Senate committee is no longer there does not address the two capacities of both the chairman and the president pro tem, who have been reelected. And again, this is a question about the state Senate and its authority. We've also argued, as you see in other cases involving this, that this is something that is capable of repetition, and so we need an answer now. And also that the subpoena itself would not be void because the committee has, that session of the General Assembly has now ended. Void would be if there was something wrong with it to begin with, and the court decided that there was nothing wrong with it to begin with, and it is in fact enforceable. We're waiting on that decision as well. And so where things sit are, the Senate has the authority to issue subpoenas. It does not need the consent of the House to enforce valid subpoenas. We're waiting on the scope of the question, but that's more of a question about, whether attorney-client privilege provides and what documents. It really doesn't deal with the authority of the legislature or the Senate. And we're still kind of waiting to see what the scope of testimony, if there would be any limitations on that. The rules do provide that the district attorney could be represented by counsel, and as we argued to the court in December, if there's a question that is believed to cross the line into privileged information, the district attorney can assert that privilege before the committee, just as anyone else could before a legislative committee. So that's where we're waiting on things now, and we'll just have to see where the court decides. There was mention, I'll say this last bit, immediately after the December 23rd order, we read in the newspaper that through counsel, the district attorney was going to immediately appeal. That never happened. If they were to do that, they would have to ask the court for permission to appeal. They never asked the court for permission to appeal. And right now, we don't have a final order, so there's no right to appeal. It was going to be up to the court's discretion. So until we get a final order, that may be what they're waiting on, or it could be that, the thinking was, let time run out when the new General Assembly comes in on January 13, make the arguments that we see in the motion to dismiss. I don't know, and I can't, I don't want to speak for the district attorney or their counsel, but that's where things stand today.
So do you have any kind of time frame of when you'll get this final order that could be appealed by either the DA or by us if it goes adverse?
I wish I did, and I know, obviously y'all are going to be talking a lot tomorrow about lawsuits generally and so on, but it is one of the great frustrations of both practitioners and clients that they're in very few circumstances do you have any kind of knowledge of when the order is going to come out. Typically, you only see that as if there's not a ruling within 30 days, something's deemed affirmed. But this is not one of those cases.
So our hearing, because Senator Kennedy and myself attended, I think, back in December, she had a ruling within just a couple of weeks after that. Is there any reason why this particular issue would be more complex or take longer to get us the word yay or nay?
It could be that the motion to dismiss that was filed on the 17th, we responded to that timely earlier this week. And so, that under Superior Court practice, there's no timeline to file a reply brief. There's no obligation to do it. So she could rule, quickly now. And also, there's no injunction or request for an injunction pending, and those tend to get ruled on faster. But in this case, the court has had, for some time, the responses back and forth on the scope of the subpoenas, but has just recently received the response on the motion to dismiss.
Right. So is it something where we would be well-served to reissue the subpoena now that we're reconstituted and a new resolution to sort of eliminate that potential argument?
I think, we have argued certainly that the committee does not have to reissue the subpoenas. I think the committee could reissue the subpoenas, and particularly if they're in the same substance and form as the prior ones. The question of whether those subpoenas can be enforced has already been decided by this court, and I don't see a reason why that would change. The question of whether the requests are too broad is currently before the court and has been briefed, so I don't see the need to proceed and re-brief that or have any additional delay on that. And yes, it would, I think, remove the argument. Now, that said, as in any legal case, I can't say that the other side won't say that the whole process needs to begin again.
Well, on the witness subpoena, I don't remember the date we had asked her to appear. It may have been that September 13th meeting. Okay. So obviously that date's in the past. So we have to have a new date, and we have to give her adequate notice to appear that date. So almost mechanically, there's no way to force her to appear 3 months ago. So we need to reissue that subpoena and select a new date and time to instruct her to be here. And that, the same argument's already been ruled in our favor, right?
Correct.
Okay. I want to take action during this legislative session. It's more convenient for all of our members. We're on day 20. You know, we got 6 weeks to go here, and so I may get with you to ask your advice what's fair time. I have a good relationship with Governor Barnes, who is our counsel. He accepted the acknowledged receipt of the subpoena last time so that we didn't have to have a dog and pony show of a sheriff's deputy serving the DA with the subpoena, and it was very professionally handled. I will plan to reach out to him again to ascertain a date that's convenient for her and for him, and I'll try to make it during session, but pretty near term, and I'll let you know, okay?
All right.
We will have you to review that witness subpoena, and then I guess I'll confirm whether we need or should reissue a document subpoena for production of documents.
Okay.
All right. I am receiving questions from a lot of senators in both parties as what is the timeline of an appeal. So let's say the trial judge rules a final ruling on the documents that have to be produced and the enforceability of subpoena next week. Is there a length of time that the DA has to appeal that?
There's, yes, and it's a little bit interesting because it's, you know, the entire case is the enforcement of a subpoena. Usually the subpoena question is one in discovery about a case on something else. So I'm going to take the conservative approach and presume that she has a right to appeal because it is a final order, even though typically questions of the enforceability of subpoenas are what we call discretionary appeals, where you need to ask the Court of Appeals permission to appeal. And in that case, if that were the decision, you have, or a party has 30 days to file what's called an application for discretionary appeal with the Court of Appeals. The Court of Appeals then has 60 days to decide it. It moves pretty quick, and within that, there's briefing. If they decide to accept it, then it moves just like a regular appeal, which I'll turn to now. If it's deemed a final order as a traditional order, you know, verdict X or injunction Y, done, you appeal. They have 30 days to file a notice of appeal, and then you're back on the same kind of calendar here. Fulton County's Superior Court clerk has to pull the record together and send it up to the Court of Appeals. This is a very small record. I mean, we're talking 2 or 3 accordions at the most, and most of that is briefs. We don't have a lot of exhibits. There was no testimony taken. So this should not take long to do. Hopefully, you would be looking at weeks, not months, but here again, there's no set timelines in the code about when it would go up. Once it goes up, when the record is there, the Court of Appeals will issue what's called a notice of docketing. At that point, that means the court has received it. It has assigned the case to, or this would probably, I think, go to the Supreme Court, because the issues, the underlying issues are constitutional in nature, and that is a direct appeal to the Supreme Court. So the Supreme Court would issue a notice of docketing. The party who has made the appeal has 30 days to file an appeal. It may be 20. Forgive me if I'm it's 20 or 30, because I think they differ in the Court of Appeals and the Supreme Court. The response is due 20 days later, and the reply brief is due 10 days after that. The Supreme Court has what's called a 2-term rule. They have to decide it within 2 terms, which is effectively a year and a half. You have to request oral argument. In a case like this, you know, one of first impression in Georgia, because we don't have law on subpoenas issued by legislative committees or a chamber of the legislature, you know, it may be that they would grant oral argument. Don't know. That typically does not slow it down, and parties have an opportunity to file or seek what's called an emergency review. And we see this a lot in election cases. So where someone has challenged an election result, you have a trial court ruling, you move for an emergency review to get the court to act quickly, because if that person is sworn in, the challenge is over. There could be grounds, and I think probably best to discuss that one in executive session as to whether this would qualify for an emergency basis, and whether that's something the committee would want to do. But that would be something that could speed up the process. The Supreme Court would have to agree that it is an emergency, and if they agree that it is, they will decide it much, much faster.
Right. So your opinion would be it would go directly to the Supreme Court?
I believe that's right. And if we were mistaken on that, it is not a fatal error. They just send it back to the Court of Appeals or vice versa.
Okay. Well, I'm going to ask you to, you may have already done so, but to provide a copy of the judge's order of December 23rd of 24 to the Secretary of the Senate to be kept in the record of this committee. I don't know that we have done that because we didn't meet again after September 13th. I know you provided that to me, but I don't know that it's in the record. It needs to be.
Okay.
If you can do that, and would you likewise do that as soon as there are any other rulings in this litigation? Just give it to the Secretary of Senate. He will mark those as exhibits for this Special Investigative Committee. I'm going to proceed with the scheduling of another hearing for this committee for the purpose of receiving testimony from D.A. Willis, as well as I may request the testimony of other individuals. So we're going to continue working as the legal case plays out, but I need you to keep us apprised. If there's a time where you think you need advice from this committee to give you direction, like last time we had to pick a strategic path, what type of litigation to pursue, let me know and we'll call a meeting to do that. We can do that very rapidly, especially when we're in session and we're all here and we can check and get time where folks can be here. Because I feel a little bit of an urgency, and we have 2 years here to deal with, but this is an issue that's been pending for quite a while, and I'd like to go forward post haste.
All right. Yes, sir.
The second question I have for you is there any need to substitute this committee under Senate Resolution 5 as a party plaintiff? We're reconstituted the same committee, but I'm just wondering, give that some thought and let us know, because last thing I want is some technicality to say, well, that's from the committee from the prior biennial and they're gone, and so it's a moot point. If we can do that, it's logical. I just want to make sure that we don't get beat on some technicalities. We're all trying to get to the same place, and the DA has a firmly held belief that she's not subject to our authority. And she's fighting that out in courts, and that's why we have the courts. It sounds like the judge has ruled our way on every single issue we raised and every theory of enforcement of a subpoena, and I am confident, based on Mr. Morelli and other advice we've gotten from counsel here that was public in meetings, that it's pretty, indisputable that we do. We'll just have to have the court say so with this particular witness. Right. Other members have questions for Mr. Belafonte. Any on the update of where we stand on our attempts to get answers? Okay. I think that any additional or new legislation we might pass would not affect your case. Am I right? I mean, if we pass a bill now, it can't retroactively assist in the pending litigation. Is that right?
If it is deemed procedural, courts have said bills can apply retroactively, and they are presumed to apply retroactively if it is procedural. If it is deemed substantive, it cannot. So it depends on what you would be looking to do, and I would have to research whether grounds for the issuance of a subpoena is procedural or substantive in this context. I don't know that answer right now, but that's the general kind of rules on it.
One thing that occurred to me is that we might want a statute that applies to special investigative committees, which the prior statute said the legislature in general, and that was one of the arguments. Oh, that meant both bodies, not just the Senate. And I think that's something we ought to contemplate going forward. I don't think that impacts the current litigation, but if it does favorably, let me know and I might proceed with that, if that makes sense at all. Otherwise, we've been kind of waiting on the wrap-up of our investigation before we gave new legislative recommendations, but we're clicking along the calendar pretty quickly here, and we want to be effective. Any questions? I saw you reaching, Senator Hatchett, for your button over there. Do you have a question or a comment?
I did, just about the procedural nature that you were discussing about if we were to amend the pleadings necessarily to substitute ourselves as new plaintiffs, would that be a new action, or could we actually substitute as a plaintiff? I've heard of substituting defendants.
I think there would be a way to do it. My recommendation at this point would be, if I were to get into the specifics of it, I'd probably rather do that in an executive session.
Okay.
But I have some ideas on how that could be accomplished. And we have things like this. For example, I represent the state in numerous instances where, you sue a DCH commissioner, and then you get a new commissioner. And in federal court, it's deemed automatic. In state court, there's a process, and it happens pretty quickly and easily. I think there's some opportunities here to have a similar result.
Let me know if you think you need further action for us or need to meet with us in an executive session, and I'll call a meeting in short order to do that. Thank you so much for giving us that update. It's good to hear it from you, since you're the attorney there in the courtroom and know it without any interpretation or ambiguity. Thank you for being here, and with that, we are adjourned.